data breaches, decisions to withhold product defect and case settlement information, failure to disclose corporate wrongdoing, firings for discovery abuse, personal liability for failing to live up to the regulators' vision of them as gatekeepers. In-house counsel are increasingly under fire. Trial lawyer Joel Hoxie of Snell Wilmer will discuss trends in government prosecutions of corporate counsel, the tensions between in-house counsel's role as counsel to the company and their duty to meet government expectations. Please welcome Joel Hoxie.
Well, to be sure, the regulators have in-house counsel in their sights these days. Both in-house counsel and internal corporate compliance officers find themselves in the line of fire because they are viewed as essential gatekeepers in the fight against corporate lawbreakers. Certain regulators, like the Securities Exchange Commission, have held this gatekeeper view since at least 2002 when the Sarbanes-Oxley Act was implemented. And some commentators would say that this gatekeeper view, at least with respect to the SEC, can be traced back even further to the early 1980s. So how do we really define the gatekeeper policy? A good discussion of it can be found in a speech that the SEC's general counsel gave to a corporate counsel group 10 years ago. Giovanni Prezioso, the then GC of the SEC, explained that the SEC had long recognized that many securities law violations could not occur without the participation of lawyers who have the professional responsibility and the knowledge that can often prevent corporate misconduct that is harmful to investors. But on the other hand, both lawyers and the SEC alike acknowledge the importance of zealous advocacy in securities laws matters and have resisted policies historically that might chill lawyers' ability to advance that objective. And this is because in-house attorneys sometimes have to make difficult legal judgments when their advice is sought by their employers. And they may feel justified in a particular circumstance taking a legal position with which SEC staff may disagree. So the SEC for years examined attorney conduct as different points on a spectrum. On the one end of the spectrum is attorney advice. The SEC historically has not targeted corporate counsel for merely giving bad advice, quote, even if that advice was negligent or perhaps worse. Now, on the other end of the spectrum, however, is pure conduct. And the SEC for years has said that it will not hesitate to go after in-house lawyers for misconduct as opposed to giving advice that, if carried out by any other corporate insider, would give rise to an enforcement proceeding. And as the SEC's GC explained when he gave his talk, he said, just because you are a lawyer does not mean you get a pass to engage in conduct that would constitute a violation for anyone else at the company. Insider trading, for example, or knowingly preparing an opinion letter containing misstatements of fact or law. So under this spectrum approach, we see conduct on the left, advice on the right. The more an in-house attorney is acting as a lawyer and actually giving legal advice to his or her corporate client, the less likely the chances of being the target of a regulatory action. As an example of how these principles explained by Mr. Prezioso have played out in the real world, consider the regulatory action the SEC brought against one general counsel several years ago. John Isselman was the general counsel of a tech company. Problems began for Mr. Isselman one day when the company's chief financial officer unilaterally terminated vested retirement and severance benefits owed to the company's employees in some of their Asian facilities. The CFO did this so that the company could avoid reporting a loss for the just ended fiscal quarter. Now, Mr. Isselman knew nothing about what the CFO had done until one day he attended an audit committee meeting to review the company's quarterly results. At the meeting, the CFO reported to everyone that benefits to the company's Asian employees could be unilaterally terminated and that the decision to eliminate the benefits had been approved by legal counsel, an outright false statement. Then, several days later, in connection with the auditor's review of the quarter's financial results, the company gave the auditors a memo stating that the foregoing employee benefits had been eliminated because the company was under no obligation to pay them, and that the decision to eliminate the benefits had been approved by both the CFO and the CEO. Isselman then asked outside counsel in Japan for an analysis of the issue. He was advised in a written memorandum by Japanese counsel that the benefits could not be unilaterally terminated. Isselman, however, did not convey this information to the audit committee, nor did he convey it to the outside auditors. Several days later, Isselman tried to raise the issue in a disclosure committee meeting where the group was reviewing the 10Q that the company was preparing, but the CFO shut him down. Isselman failed to push back at the meeting, and he did not provide outside counsel's written analysis to those participants in the meeting. After the meeting, he did give the CFO the written memo. Now, before the 10Q was filed, an audit committee member asked Isselman specifically about language describing the elimination of the employee benefits and the resulting accounting entry. But even then, Isselman did not inform the committee member about the Japanese counsel's written opinion and his analysis. About a month later, after the 10Q had been filed, Isselman discovered that the CFO had eliminated the benefits to compensate for an accounting error that had negatively impacted the company's earnings. Isselman at that point alerted the audit committee regarding the CFO's misconduct. An internal investigation ensued, the upshot of which was that the company had to restate its quarterly results. Turns out the company's original reported net income had been overstated by almost 30%. The SEC then came in, brought an enforcement action against Mr. Isselman. The SEC's conclusion was that it was Isselman's inaction that caused the company to file a materially false and misleading 10Q. Isselman was hit with a cease and desist penalty and a $50,000 fine. So where did Mr. Isselman fit on the spectrum between advice and conduct? Well, clearly he was down at the conduct end, actually lack of conduct, as he didn't really act as a lawyer and give any advice to his corporate client. So what is it that Mr. Isselman failed to do? Well, at least four things. He failed to respond to red flags. He failed to speak up. He failed to convey legal advice to the appropriate people within the organization. And fourth, he failed to fully respond to questions from directors and other board committee members regarding legal issues that were being raised. Now, over the last few years and many corporate scandals later, the SEC has been taking an even stronger position toward in-house counsel's role as gatekeepers. In-house counsel and other gatekeepers, as I said, such as compliance officers, are now much more likely to be the target of enforcement actions when they have a clear responsibility to implement compliance programs or policies and they wholly fail to carry out that responsibility. Consider, for example, the current chair of the SEC, Mary Jo White. Chair White spoke out last fall that aggressive enforcement against wrongdoers remains a top priority. She is acknowledging directing staff when conducting an investigation to first assess whether individuals could be charged even before looking to bring a case against an entity. She also said that if the SEC cannot prove intentional fraud, it will bring actions premised on negligent conduct. And this appears to be a departure from the SEC's view 10 years ago, at least as then explained by the SEC's general counsel. More recently, Chair White said that the SEC has adopted a tough cop approach, aiming to be everywhere, pursuing all types of violations, big and small. She reiterated the Commission's focus on gatekeepers, especially in the financial industry. But she did caution that the SEC, quote, will not be looking to charge a gatekeeper that did her job by asking the hard questions, demanding answers, looking for red flags, and raising her hand. Now, these same principles have been emphasized by others at the SEC as well. We have, for example, the SEC Enforcement Director, Andrew Seresny. He noted in a talk he recently gave that in fulfilling the Commission's promise to aggressively enforce securities laws, the Commission will continue to bring its resources to bear by initiating cases against gatekeepers in their individual capacities, notwithstanding what actions are brought against the corporate employers. And then we have Commissioner Kara Stein. She recently addressed the role of corporate compliance officers as gatekeepers in a talk she gave at an ABA section meeting. She said that in the cases we bring, you will see that they are not cases against chief compliance officers that were promoting compliance. Instead, they are cases against CCOs that were assisting fraud, ignoring red flags, not asking the tough questions, and not demanding answers. She also added that in-house lawyers have a great responsibility, whether drafting and implementing policies, influencing executives' decision-making, identifying risks, investigating allegations of misconduct, or reporting violations. Now, a recent example of the SEC's approach involves the General Counsel of Life Partners Holdings, who was hit with a substantial civil penalty as a result of his company's false SEC filings. In that case, the Commission brought a civil enforcement action down in Texas against Life Partners Holdings, its CEO, Brian Pardo, and the General Counsel, Scott Eaton, for fraud and providing misleading securities disclosures. Now, the evidence at trial revealed that when the company's outside auditors informed the CEO that it would not sign off on the company's disclosures because they did not comply with GAAP, the CEO sent an email threatening to sue the auditors unless they would sign off on the company's accounting methods. In the end, as to the GC, Mr. Eaton, he was found to have provided assistance on 17 false reports, and he was hit with a civil penalty of $2 million. Now, the Life Partners case raises another real concern for corporate counsel these days, and that is a poor compliance culture at the company. Now, even if Mr. Eaton hypothetically had tried to serve as a gatekeeper, his efforts likely would have been in vain, as his boss apparently had no respect for corporate compliance. But the evidence does not support that hypothetical as to Mr. Eaton. It does, however, remind me of another company with a bad compliance culture and how that company's general counsel suffered as a result. That company was KLA Tencor, and this was back 7-8 years ago when stock option backdating was a prevalent tool used by companies throughout the country, especially out in Silicon Valley. KLA Tencor's general counsel had been asked for advice about stock option backdating, and he provided good, sound advice to his CEO explaining that stock option backdating was potentially illegal. And here is the email Mr. Nichols received from his CEO, Kenneth Schrader, in response. That back here, there. So his CEO was looking for a war counselor, not someone who could recite page and verse. And I'll note this is in contrast to how Michael Corleone regarded his friend and family legal counselor, Tom Hagen, in the film The Godfather. Michael Corleone wanted to take his friend and legal counselor out of the fray and did not want him to be a wartime counselor. These days, even taking an aggressive gatekeeping function, though, can afford little protection, notwithstanding what we hear in the speeches from the SEC. Consider the case against one general counsel that was brought recently. Theodore Urban was the general counsel of a boutique investment firm. He served as a member of several compliance-oriented committees. And soon after joining the firm, Mr. Urban and the firm's compliance officials became concerned about the activities of one of the firm's retail brokers. Now, Mr. Urban prepared a memo to senior management explaining the concerns regarding this particular broker and recommending that the broker be terminated. He also had his compliance staff file a report with the New York Stock Exchange regarding the broker's unauthorized trading activities. Notwithstanding that Mr. Urban reported up and exposed the broker's illicit trading practices, the SEC still brought a failure to supervise charge against Mr. Urban, even though Urban was not the broker's direct supervisor. This case proceeded to a full-blown hearing where the administrative law judge, after considering all the evidence, dismissed the charges against Mr. Urban. Even then, the SEC staff appealed. Subsequently, though, an evenly split commission affirmed the dismissal without an opinion. So in this case, Mr. Urban did serve quite aggressively as a gatekeeper, and yet the SEC still took action against him, albeit unsuccessfully. Nevertheless, Mr. Urban was dragged through the mill of a full-blown regulatory action. As I said at the outset, it's not just the SEC these days. Other regulators are targeting in-house counsel. So you have FinCEN, the U.S. Treasury's Financial Crimes Enforcement Network, and you have FINRA, the Financial Industry Regulatory Authority. Both are seriously targeting money laundering. You see, FinCEN brought a $1 million action against MoneyGram's chief compliance officer, and FINRA imposed a $25,000 fine against Brown Brothers Harriman's money laundering compliance officer, even though that official recognized the activity, reported up the ladder, and implemented programs to protect against the activity in question. The FINRA's response, however, was that they penalized the officer for inadequately responding to the red flags. Now, some of this recent enforcement action has been criticized. Outgoing SEC Commissioner Daniel Gallagher has been a dissenter in two recent enforcement actions against compliance officers at investment advisor firms. He's been critical. He said that the regulation the compliance officers were charged with violating was vague, that it detailed compliance responsibilities for firms and imposed obligations on firms rather than the firm's compliance officer or in-house counsel. And he noted that the commission had failed to offer any guidance to compliance officers on how to comply with the regulations in question. And so in criticizing these particular actions, Commissioner Gallagher says the SEC is, quote, cutting off the noses of chief compliance officers to spite its face. Wednesday of this week, an administrative law judge, Cameron Elliott, declined to sanction a Wells Fargo compliance officer, even though finding she had aided and abetted and caused a regulatory violation in the insider trading area. He said, quote, there is a real risk that excessive focus on violations by compliance personnel will discourage competent persons from going into compliance and thereby undermine the purpose of compliance programs in general. So what are the takeaways? First, the regulators are under a lot of pressure from Congress and the public to go after corporate wrongdoers, and this includes individuals, not just organizations. Clearly, a more aggressive enforcement program targeting gatekeepers. Based on what a number of in-house attorneys are telling me, there is much more of a gotcha attitude out there these days among the regulators. It used to be, they said, that compliance within the spirit of the law was sufficient. That no longer appears to be the prevailing attitude. I think it still comes down, however, to attorney conduct versus attorney advice. You should do everything you can in a tough situation to make sure you'll be seen as at or near the advice end of the spectrum. I think it's important to be aware of the KLA 10 core problem, recognize management's approach to business and ethics, recognize the need for adequate resources to do your job. You think about using outside counsel for advice, and use national and local corporate counsel associations and peers as a resource. And finally, make sure you're being aggressive, make yourself heard, and demand answers. Thank you, and have a great weekend.